Good afternoon and welcome to GNAT. I'm Don Keelan, the co-host of Civil Discourse, and with me today is my co-host, fellow colleague here, Andrew McKeever, the head of the news here at GNAT. We have a very special guest today. We have the Honorable Erica Marthage, who's the state's attorney for the county of Bennington. Erica, I should say. I keep saying Martha.
Everybody does that.
Welcome to the show.
Thank you.
Thank you for taking the time
here.
To be with us. Erica is no stranger to Southern Vermont. She is a graduate of BBA, also then went on to the University of Vermont, where she got her bachelor's, and then went on to the University of Connecticut School of Law and became an attorney. And in 2001, you became a deputy assistant attorney in the Bennington office of the state's attorney. Is that correct?
Yes.
And then,
yep.
In 2007, was elected the state's attorney and has since held that position. How often do you have to run for re-election?
It's every 4 years.
Every 4 years. And and she holds that position right now. Again, welcome and thank you for being with us
You're welcome.
Today.
Glad to be here.
One of the questions we have, we'd like to ask you, you do a great deal of negotiating to resolve conflicts, and some of it must get very difficult. And to use to coin a phrase of our previous guest, Amanda Ripley, who wrote the book High Conflict. Mm-hmm. You must get into some serious conflict.
Definitely.
Can you share how you? What we'd really like to know is, without going into the details of it all, how do you resolve that?
So I actually watched your episode with Amanda Ripley and found it fascinating. Conflict and negotiation is a overwhelming part of what we do. Probably 95% of our cases result in some type of agreed upon resolution, whether it be a plea agreement, a dismissal as part of a bigger picture, or sometimes we're convinced by the defense attorney and the defendant that dismissal would best serve the interests of justice. So how I personally deal with it and how I've tried to encourage the bar that in my office that works for me to deal with it is you really can't think about the person you're negotiating with as the other side, so to speak, or like the philosophically diametrically opposed to you. You have to think about each case as this is a situation where we each have our role to play. The role of the defense attorney is to represent the best interests of their client. Their role is also to ensure that all of the rights, constitutional rights, are being met by the system and how it's happening here, whether it be from the police officer stop all the way through to they have a right to maintain a not guilty plea. So the most difficult thing when you first start in this area, whether you're a defense attorney or a prosecutor, is getting past the fact that just because they're saying they didn't do it, that's not personally attacking me. It's not a personal attack on the officer. They have a right to maintain a not guilty plea. And that continues throughout the entire case. You cannot assume that every time the defense attorney emails you and says, look, my client says that they have an alibi. The biggest mistake you can make as a prosecutor is not examining that alibi and make sure that you have either a response to that or maybe it's true. Maybe you have received information that you didn't have before. And vice versa, the same is true for defense attorneys. The biggest mistake a defense attorney can make is assuming ill will on the part of the prosecutor. It's not our job to convict innocent people. It's not our job to just go out and get as many convictions as we can. Our job is to be the person that enforces the laws of the state of Vermont. We want to convict the person who actually committed the crime. And ultimately, we want an outcome where we are rehabilitating that person. If punishment is something that should happen, we want to make sure that that happens. And we want to keep the public safe. So there are a lot of restorative practices that go into negotiation. Just because someone isn't referred to the Center for Restorative Justice or diversion doesn't mean that we're not still crafting some type of restorative sentence. And that's important for both sides to be thinking about that, the defense attorney and the prosecutor.
I wonder if you could walk us through how plea deals get negotiated. I would imagine you start off saying, well, guess what? If you're found guilty, you're going to go to jail for 10 years or whatever.
Right.
And the defense attorney says, no.
Right.
What if we did this to get it down? Does that go on like all the time?
Oh yeah, definitely, but not to that extreme. It's really not like a horse trading kind of thing. We those of us that have been doing it a long time really refer to it more as making sausage, right? So we're taking, although, for example, a burglary of an occupied dwelling may hold a 25-year maximum potential sentence, highly unlikely anyone is ever really looking at 25 years in jail. That's a number that the legislature put on it. The reality is we receive the paperwork, we review the charges, we make charging decisions. The legislature has put what the potential penalty for that particular crime is on the books, but then our paperwork also includes an offer sheet, an initial offer sheet. So there are differences among counties of how that is treated. Some counties treat it, as you said, they'll say, well, look, you could be looking at 25 years in jail. You should just, let's start there. Some offices, more like my office, would look at it and say, okay, if you plead guilty at this stage of the process, this is what we would be looking for. And it's more of a realistic request. So we would make an offer, say, on that burglary of an occupied dwelling for someone who has a history of this kind of thing. We would make an offer that's like, we want 5 years to serve, and we would put minimums and mandatory, all that stuff on it. But if we were looking for 5 years of incarcerative time, that might be what we're looking for. If it's someone with no history, say you burglarize a family member's home, you suffer from a substance addiction, we would probably be looking at no jail time and something that looks like probation with drug treatment. But we would put that on the offer sheet. And then the defense attorney literally they almost never, because they need time to speak with their client. The idea that someone would walk in and plead guilty at arraignment is ludicrous. So we typically keep that initial offer open for a period of weeks. Sometimes we usually go by the court appearances. So you get arraigned, 2 months later you come back for just a conference. We would keep that offer open for a period of time. And then it's like there's the starting gun. Now we just start going back and forth. Well, I don't want drug conditions. Will they live in them? Well, they already got into this treatment. And it really is that kind of back and forth. And the significant delay sometimes can be, if they're front loading the things we'd be asking for anyway, like substance abuse treatment or mental health treatment or alcohol or, get your license back and, those kind of things. Those take time, so it delays.
Let me follow up on a point. I think you made it. But we also heard it from Amanda Ripley. We also heard it from a previous guest, Dr. Johnson, Russell Johnson from the University of Chicago. It's them versus us. I'm going to, now you're over here, it's us.
Yep.
All right. And then over here, it's them, the defendants and the defendants' attorneys, and I guess the defender. I was going to say the defender general.
Public defender.
Public
yep.
defender. Thank you. How do you avoid not falling into that pit?
This is the most fascinating part of my job at all, and it's developed over the last 20 years, right? So I've been doing this since 2001. I've been a prosecutor, and watching how my own approach to negotiations has changed has been really eye-opening. And so I'm trying, much in the way that Amanda said, there's good conflict, there's high conflict, and those are things that I'm constantly trying to help the people that work with me or around me get to the point where you really need to think about it not as an us versus them. And to get past that, it's not assuming the worst of the person that you're negotiating with, in this case, the public defender. So in other words, don't assume that they're being loose with the facts, and don't assume that they're not being forthcoming about the information they can share. And then from my own perspective, not walking down that path of assuming, well, this person's been charged, so they definitely did it. They did it as far as I am aware, right? We don't charge people that we just think may have done it. I mean, we're filing criminal charges on people that we have, probable cause and witnesses and evidence, and this is the information I have. Many years ago, I learned in a case where I had a gentleman that had repeatedly been convicted for stealing things. I get a police affidavit, a hotel in Bennington had made a complaint that he had stolen the microwave out of the unit he was renting. So we have the statement of the owner, we have the VIN number on the microwave, saying that he took this microwave. He was telling his attorney that the microwave in the room had broken, they weren't replacing it, so he went down to the Salvation Army and bought one and put it in the room. So when he left, he took it with him. Someone that is taking that high conflict approach would just assume, yeah, that's BS. He's just saying that. Like, that's far-fetched, whatever. My approach at that point was, okay. I send the investigator down to the Salvation Army. Hey, do you keep VIN numbers on small appliances? Well, wouldn't you know they do? Which I didn't know. So that was new information. And yes, he purchased this microwave. That was 12 years ago in my career. And I still remember that, and I still think that every time I have a defense attorney tell me something that may or may not be far-fetched, I'm looking into it. And we are so lucky in Bennington to have a relationship with our public defenders where they are doing their job. They cannot share all information with us, right? Because they have a different obligation to their client. They have a privileged relationship with their client. Maybe they know things they're not telling us, but we can't hold that against them, and we don't. And so over the last, 16 years I've been in office, we've really developed a relationship where they're not always assuming the worst of us, and we're not assuming the worst of them. We each have our roles, we're doing them. Sometimes we can't come to an agreement, and we have a jury trial. That's the system.
It's fascinating to me hearing you describe how that process works. I mean, the basic premise of our show here is to talk about how we can have civil conversations with people who hold different points of view, political or otherwise. And maybe this comes from watching too many detective shows on television or something like that. But I guess I had this image of attorneys and district attorneys and private defenders sort of going head to head, in the office off the stage. But that doesn't sound like that's the case at all. You actually kind of sit down and have civil dialogue about how we can work this out for the best interests of all the parties.
That's right. And so very frequently I find myself describing that when we are in a jury draw to, this is not like television, right? We don't get DNA results in a day. We don't get, we're not having this like antagonistic relationship with the other side. I joke all the time that, you know, I'm just telling you, if I ever get arrested for anything, there's an attorney in the public defender's office that I'm calling that guy. So, because we are all professionals, we're all grown-ups, you cannot overestimate the importance of respectful, thoughtful discourse, because the minute the tensions are high already. The other parties have the high tensions. The victim, the victim's family, the defendant, the defendant's family. And the minute the people that are supposed to be appearing in court and representing those interests get sucked into that volatile, emotional, is when it all falls apart. And it's not happening the way it should.
You mentioned, you know, how you handle it. And again, going back to our, you know, the civil discourse part of our effort here, how do you, if I join your firm right out of law school now, I came in as not your firm, your office, I guess it is a firm,
Yep.
Or that of the public defender, I have been trained in law school, from what I've gathered, on handling negotiations, and you know, there's some discussion about it, but not the way you deal with it. How do you convey to your new folks who come into your office, this is what you need? I mean, you got over 20 years.
Yeah.
And but they don't.
Yeah.
And yet they have to negotiate. They have
Right.
to. They have to make sure it's not us versus them.
Right.
How do you convey that?
So I always start, and I started doing this probably 10 years ago, every single staff person that joins my office, whether it be an administrative assistant, a victim advocate, a deputy, whoever it is, I have an outline of, we're not playing hide the ball. If you have a piece of information that needs to be shared with the defense, do it, and do it right away. We're not playing games. We're respectful to everyone we deal with. Defendants, parents, defendants' family, victims, everybody. We are respectful when we interact with other individuals. So not only do I give that little speech, I have a couple of months usually where I have that person follow. They have to shadow for a pretty substantial period of time. All negotiations, all like depositions, for example. We have someone that will either, now it's even easier with the video, you know, so many things are being streamed, including a lot of our depositions. So I can have a new person sit in and follow. The last couple of individuals to join my office, I copy them on a lot of the negotiation emails that I have, because I would tell you what I learned just recently, which I thought was fascinating and hadn't occurred to me before. Even at I teach at the police academy. I teach courtroom demeanor, and another individual in my office does that as well. We've been doing it for years. We spend a lot of time talking about the idea of treating everyone with respect, listening to what they have to say. There may be some information in there that you can use, but it also just builds a rapport with the general public. The police academy does a number of training scenarios when you're at the academy. Well, all the training scenarios involve kind of unusual circumstances, right? It'll involve, you know, you stop somebody and then they try to run, or you stop somebody and they have drugs in the car. What they don't practice is how do you interact with just the regular, law-abiding, pleasant person that happened to be speeding on one day, right? You don't have to be, and not everybody does this, but not everyone has experience talking to people, and I'm finding that it's even worse the further we're getting into this digital age, right? I mean, you know, I'm a Gen Xer, like that's many letters ago. So the Gen Z people now have much less face-to-face communication. So we're really losing that ability to negotiate, to have literally a civil discourse with other individuals. And so I find the best way to achieve that is just shadowing, role model, field training officers. Most programs, VSP has a very strong field training officer program where, new people follow the people that have been doing it for 20 years.
Can I interrupt just for a minute? I want to, because I know we're sort of timed here. It puts me under the gun here with this clock. Are there times?
Someone's got to do it.
I could talk about this all day. I love
I know you do.
discourse. Yeah.
It seems that way. Are there times when you just have to walk away from negotiations and matters that you just can't resolve?
Yes.
And do you feel that's a failure of what you've been trained to do, or it's just the way the party, the other side, or?
No, I mean, it's not a failure, because the interesting kind of finish line for the system I'm in is everyone has a right to a jury trial. Yeah. So if you're charged with a crime and you're maintaining that I did not do this, then you absolutely should have a jury trial. And the important thing that you need to remember, the parties need to remember, both the prosecutor and the defense attorney, is that it's not personal. So when someone says, I don't care that you're offering me diversion, I want a trial because I didn't do this. There's a whole separate conversation about whether I would actually use publicly funded resources to have a trial on something that should be a diversion referral, so like a simple assault.
But I'm a 10-year-old. Sometimes people accuse me of being 10 years old. But I'm a 10-year-old, and I'm a witness.
Yeah.
And myself and my family
yep.
do not want me to go to
court.
Go to court.
Yeah.
Right? You're doing your best to try to prevent that by asking for a
yes.
plea. On the other side, it's they don't want to.
And if they say no, then I'm back to that weighing.
Yeah.
What is the case? What are the ramifications if I don't take it to a trial? I mean, child sexual abuse is a very real phenomenon where that happens, where victims' families come in and say, my 10-year-old does not want to testify in open court.
Forgive my ignorance, but the family of that 10-year-old, they don't get to negotiate.
No, not directly. They don't get to negotiate. The interesting thing in Vermont, and it's every state, has a victim advocate program. So every statute in Vermont there is a requirement. The judge needs to know what the victim feels about this. And if it's a kid, it would be the victim's family.
Okay.
So we have about 5 minutes left since I'm playing the timekeeper role.
Fast.
But I was wondering if, as I'm listening to this conversation, are there some cases where the passions really do tend to kind of bubble up to the surface? I'm thinking things like domestic assault or a drug case, for instance, where someone died of an overdose, let's say, and the victims' families are in court. I would imagine there must be some cases where it's really hard to kind of keep things in a very sort of,
Yeah, and some of it is, you mentioned drug overdoses. So, we prosecute individuals who sell drugs and that then results in an overdose death. And those cases, the people in the courtroom, the civilians or the people that are involved, whether it be friends or family of the defendant or friends or family of the victim, are very high emotion about, you have the folks that, my son may have sold the drugs, but he has an addiction himself, and this isn't right, and you're trying to put him in jail for this. And then I have the victim's family saying, but he sold her the drugs, and she overdosed and died. And what I try to remember, or it's easy for me to sit in my situation and have a conversation with the victim's family or the defendant's family. But what I tell the defendant's friends or family that are in the courtroom is, and if your family member were the one that had died, I also would prosecute the person that sold the drugs to them. So it's not, two of the adages that we hear all the time in my staff are, yesterday's defendant is tomorrow's victim. So almost every individual that I've prosecuted, I have also had as a witness or a victim at one point or another. And so to remember that is very important. And then the only other thing that I feel like I want to lose my mind when I'm dealing with particularly any defense attorney that doesn't do a lot of work in criminal work, in the criminal court, when they don't, they question my motivation when I say things like, we really need to sit down and have level heads about that. Like, I really want to talk about how do we get to this point. And I've been doing this a super long time, and I swear to God, it's not a trap. I'm just trying to can we just have an honest conversation? And that's genuinely it. That's why I really enjoyed watching your episode with Amanda, because she talks about that. Like, you can't us versus them, the person you're trying to...
And that's all privileged? If I was that attorney and we shared that discussion, you can't use that against my client if it's...
Oh, well, I mean, I think there are probably some people that would, certainly in the civil world. As an elected official, I would never do that. So what I have done in the past, there have been a couple of times where there have been attorneys that just are so difficult for my staff to deal with, I will assign someone else. So if I have a deputy that says, this attorney has been, I've had it happen over the years, it has been so obnoxious to deal with, so awful, then I say, I want to make sure you put everything in writing. There'll be no phone calls. There'll be no, chats in court. And I'm going to assign somebody else to the case from our staff, because what should never happen is the relationship between the attorneys impacting the defendant. That's worst case scenario.
And how many attorneys do you have in your staff?
I have 5.
And as far as you're concerned, they all have the same, it's all consistent with your philosophy on negotiation and...
Oh yeah, I'm pretty adamant about it. What I also do that is important is I don't undercut my staff or go behind, defense attorneys know if they're negotiating with one of my deputies and they don't think that they're seeing all the facts or that they're seeing it the way I would see it, they'll say to the deputy, do you mind if I go to Erica? Because if they come to me without at least saying that, my deputies will always say, go to Erica, and just so that we can make sure we have some consistency.
How are we doing on time?
Well, I've got about a minute or so left. I was interested in your comment there a while back about how the digital Zoom piece has impacted some of this communication. We've all, over the last 3 or 4 years in particular, found it occasionally difficult to navigate through that. Yeah. So does that really have an impact?
Oh, definitely. And here's why. Here's what I see. You're so easy to say things online or in the digital world that you wouldn't say to someone in person. It's so much easier to see someone, and I get it quite a bit because I'm an elected official, right? People talk about me or say things about me online or post, or they'll say things about me right in the courtroom while I'm standing there. And they forget that I'm a human too, right? That I'm a person too, and I have feelings and a family, and we're all just people. But in the digital world, you're removed from that one layer. So you might take a tone in an email or a text, or it's much easier to kind of us versus them when you're not sitting with someone and having a conversation. So, I think that that's been challenging, and I think that from a very young age now, kids are spending more and more time socializing through gaming platforms or through internet circles or whatever, and they're not building those communication skills and the ability to listen to someone else who says, obviously the political world is the big, or in this, gun control lately has been a huge, I can't even talk to you about gun control, instead of saying, so what is the reason for your opinion? Because there may be a nugget of information in there that you hadn't thought about.
Well,
I gather we're out of time, and I wish we had scheduled a lot more time. Counselor, thank you so much for being with us and sharing.
No problem.
And we'd love to be able to, if it's all right with you, to call you back in at another time.
Absolutely.
And finish this discussion, because your area is one that sees a lot of negotiations. And we're just trying to see if we can bring a civil discourse to discussions.
Yeah.
Thank you very
Thank
much.
you.